The Indecent Representation of Women Prohibition Act 1986. An act to prohibit indecent representation of women through advertisements or in any publications, writings, paintings, figures, or in any other manner, and for matters connected therewith or incidental thereto. Section 1. Short title, extent and commencement. This act may be called the Indecent Representation of Women Prohibition Act 1986. Subsection 2. It extends to the whole of India. Subsection 3. It shall come into force on such date as the central government may, by notification in the official gazette, appoint. Section 2. Definitions. In this act, unless the context otherwise requires, Clause A. Advertisement includes any notice, circular, label, wrapper, or other document, and also includes any visible representation made by means of any light, sound, smoke, or gas. Clause B. Distribution includes distribution by way of samples, whether free or otherwise. Clause C. Indecent representation of woman means the depiction in any manner of the figure of a woman, her form or body, or any part thereof in such a way as to have the effect of being indecent or derogatory to or degenerating woman, or is likely to deprave, corrupt, or injure the public morality or morals. Clause D. Label means any written, marked, stamped, printed, or graphic matter affixed to or appearing upon any package. Clause E. Package includes a box, carton, tin, or other container. Clause F. Prescribed means by rules made under this Act. Section 3. Prohibition of advertisements containing indecent representation of women. No person shall publish or cause to be published or arrange or take part in the publication or exhibition of any advertisement which contains indecent representation of women in any form. Section 4. Prohibition of publication or sending of books, pamphlets, etc. containing indecent representation of women. No person shall produce or cause to be produced, sell, let to hire, distribute, circulate, or send by post any book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation or figure which contains indecent representation of women in any form, provided that nothing in this section shall apply to Clause A. Any book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation of figure. Subclause 1. The publication of which is proved to be justified as being for the public good on the ground that such book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation or figure is in the interest of science, literature, art, or learning, or other object of general concern. Or subclause 2, which is kept or used bona fide for religious purpose. Clause B. Any representation, sculptured, engraved, painted or otherwise, represented on or in subclause 1, any ancient monument within the meaning of the Ancient Monument and Archaeological Sites and Remains Act 1958, or subclause 2, any temple or on any car used for the conveyance of idols or kept or used for any religious purposes. Clause C. Any film in respect of which the provisions of Part 2 of the Cinematograph Act 1952 will be applicable. Section 5. Powers to enter and search. Subsection 1. Subject to such rules as may be prescribed, any gazetted officer authorized by the state government may, within the local limits of the area for which he is so authorized, subclause A, enter and search at all reasonable times with such assistance, if any, as he considers necessary, any place in which he has reason to believe that an offence under this Act has been or is being committed. Subclause B. Sees any advertisement or any book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation of figure which he has reason to believe contravenes any of the provision of this Act. Clause C. Examine any record, register, document or any other material object found in any place mentioned in Clause A and sees the same if he has reason to believe that it may furnish evidence of the commission of an offence punishable under this Act, provided that no entry under this subsection shall be made into a private dwelling house without a warrant. Provided further that the power of seizure under this subsection may be exercised in respect of any document, article or thing which contains any such advertisement, including the contents, if any, of such documents, article or thing, if the advertisement cannot be separated by reason of being embossed or otherwise from such document, article or thing, without affecting the integrity, utility or saleable value thereof. Subsection 2. The provisions of the Code of Criminal Procedure 1973 shall, so far as may be, apply to any search or seizure under this Act as they apply to any search or seizure made under the authority of a warrant issued under Section 94 of the said Code. Subsection 3. When any person seizes anything under Clause B or Clause C of Subsection 1, he shall, as soon as may be, inform the nearest magistrate and take his orders as to the custody thereof. Section 6. Penalty. Any person who contravenes the provisions of Section 3 or Section 4 shall be punishable on first conviction with imprisonment of either description for a term which may extend to 2 years and with fine which may extend to 2,000 rupees, and in the event of a second or subsequent conviction, with imprisonment for a term of not less than 6 months, but which may extend to 5 years, and also with a fine not less than 10,000 rupees, but which may extend to 1 lakh rupees. Section 7. Offences by companies. Subsection 1. Where any offence under this Act has been committed by a company, every person who at the time the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any such person liable to any punishment if he proves that the offence was committed without his knowledge, or that he had exercised all his due diligence to prevent the commission of such offence. Subsection 2. Notwithstanding anything contained in subsection 1, where any offence under this Act has been committed by a company and it is proved that the offence has been committed with the consent or connivance of or is attributable to any neglect on the part of any director, manager, secretary or other officer of the company, such director, manager, secretary or other officer shall be proceeded against and punished accordingly. Explanation. For the purpose of this section, Clause A, company means any body corporate or includes a firm or other association of individuals. And Clause B, director in relation to a firm means a partner in the firm. Section 8. Offences to be cognizable and bailable. Subsection 1. Notwithstanding anything contained in Code of Criminal Procedure 1973, an offence punishable under this Act shall be bailable. Subsection 2. Any offence punishable under this Act shall be cognizable. Section 9. Protection of action taken in good faith. No suit, prosecution or other legal proceeding shall lie against the central government or any state government or any other officer of the central government or any state government for anything which is in good faith done or intended to be done under this Act. Section 10. Power to make rules. Subsection 1. The central government may, by notification in the official gazette, make rules to carry out the provision of this Act. Subsection 2. In particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely, Clause A, the manner in which the seizure of advertisements or other articles shall be made, and the manner in which the seizure list shall be prepared and delivered to the person from whose custody any advertisement or other article has been seized. Clause B. Any other matter which is required to be or may be prescribed. Subsection 3. Every rule made under this Act shall be laid as soon as may be after it is made before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in two or more successive sessions, and if before the expiry of the session immediately following the session or successive sessions aforesaid, both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, the rule shall thereafter have effect only in such modified form, or be of no effect as the case may be. So, however, that any such modification or annulment shall be without prejudice to the validity of anything previously done under that rule.